And now for something completely different. There we go. I'm just going to hand around some jackets. If we start on this table and then we move through over the next 10 minutes, you can just compare these two jackets and see what you think, and then maybe at the end we can have a chat about them. So, this is in the context of design. So, I'm going to be looking at the 7 things, and I hopefully won't be too long because we've got our coffee break coming up, and I know everybody's gasping probably for a coffee. The 7 things that people often say that you have to change to avoid copying when it comes to designs, and that's so that's why I'm showing you those jackets. So if you can have a look at those. I think one of the things that I'd like to introduce first is what is meant by a design. It's actually quite complicated under English law. There's actually 4 types of design rights. You don't have to copy this down because it's in the handout. They're all very different in terms of how long they last, whether you register, whether you don't register, and what they cover. In essence, when you're talking about unregistered design, the most important thing to remember is that in the UK it lasts for 10 years, whereas in the EU it lasts for 3 years. So in fact, when you're looking at Brexit, that's one of the issues where we actually might benefit coming out of the EU. But it also the downside about Brexit in terms of designs is the fact that designs in the EU cover surface decoration as well as shape, whereas in the UK they only cover shape. So that's another nuance that means that at the moment, when it comes to looking at design infringement, you can actually pick and choose which law you use to get your. So if you're particularly if you're trying to prove design infringement, there's a lot of scope for you to be able to do that. Registration is important because registration means you don't have to prove copying. That's another important point in that if you don't register your design and somebody copies your design, you've got to prove that they've copied it, whereas if you register it, you don't have to prove that you've copied it. Obviously, the downside to registration is it costs money, and you can't register everything. And so most brands tend to only register their most important brands or their most important designs to ring fence them in that way. So here are some examples of designs that are these are all registered designs. Some of the designs we've registered. Some of them you probably can't see on the screen. The one in the middle, that's actually a swimming pool, believe it or not, with a retractable cover. The others are probably fairly obvious. The sort of bag on the right there is, in fact, that's a waterproof bag for when you go in you can go in the sea with all your valuables, so you don't have to leave them on the beach. The others are probably quite obvious. There's some more here as well. It just shows you the fact that you can register. You can register, and certainly in the EU anyway, you can register surface decoration. So you can register things like the sort of logos there, and you can also register the sort of patterns on the dress over there, in addition, obviously, to the shape that you've got in the middle with the cosmetics. So looking at the popular myths, obviously, as I mentioned, copying is only half the story because, in fact, if you copy something that doesn't have any rights in it, then there's nothing wrong with that. So, and that's one of the things about designs. When you're trying to enforce a design, you have to show that you have the rights in the first place. So if your design is for something pretty sort of pedestrian or mundane, and people have done it before, then if somebody else copies that, there's not going to be an issue. And then looking at the 5 or 7 changes, which we'll come on to in a minute. The other thing that people often say is everyone else is doing it, so it's okay. Not necessarily. Just because everybody else is copying something doesn't mean that it's right. And then a product's been around for ages again, so it's no problem. Well, the product might have been around for ages, but it may have detail on it that is new, and if that detail is what you've copied, then that could be a problem. The test for infringement, which is where the 5 to 7 changes comes in, is, and that this is the crucial point actually, is the overall impression. So it's the overall impression on an informed user. That's the legal definition, and that effectively means if when you're looking at it as a sort of buyer of goods, so sort of not a consumer, but somebody who's in the industry. So whatever industry it might be, whether it's the swimming pool design or whether it's the jacket design, if you're sort of knowledgeable in that industry and when you're looking at both products or both items, if you, from your educated eye, think that they give the same overall impression, then that probably means that it is an infringement. So that's the key aspect, and that's when you're looking at the 7 to 5 changes. That's why it's quite important to remember that, because often what happens is people change minor things. So you can often count the changes on an item, and you'll see that maybe the buttons have been changed, maybe the seam has changed slightly on the lapel, or maybe there's been a sort of pattern introduced on the back, or even the zip has been changed into a series of buttons. If those sort of minor changes don't in fact change the overall impression that the garment has or the item has, then in those circumstances you generally find that there has been infringement because the overall impression is the same. As I said before, when it comes to infringement, if you have registered the design, then you don't have to show copying. So, and that's another fundamental point, and that is you can come up with the same design as somebody else if you've independently created it, and if they haven't, and if somebody's relying on unregistered design, they have to show copying. So you would not be infringing in that situation. So if you've kept records and you have come up with that design yourself, and you can show that would be a defence, even if it was identical to the design that the person's saying you've copied. Another important element, and I'll come on to that with the jackets, is that designs can protect parts of products. So you don't have to say that you'll protect the whole thing. You can protect the part. So the best example is like of a teapot. You can protect the spout of the teapot, but not necessarily the whole thing. So and there's been cases in relating to umbrellas where you can protect in fact the slit of the umbrella case that goes onto the umbrella, and that can be a design. So even a part of a product can be protected. So we've all seen the various sort of articles in magazines where people compare designs. I thought we'd take a bit of a look at some footwear. These are some examples of various designs. Now, footwear is an interesting example because if the design field is quite narrow, so if you're designing a shoe and it has to have certain elements, then if those elements are unlikely to be able to be protected. So as you can, and if the design field is very narrow, the changes that you have to make, if you make quite a few changes, then that can take you outside the scope of the design. So in fact, in most of these examples, I don't think there probably would be any infringement. The closest is probably the Yves Saint Laurent one, and with the tassels there, but even that, the shape is actually quite different, as you can see. The fact that the heel is quite pronounced on the one on the right. The tassels are in a slightly different place, and also the shape of the back is sort of slanting as well. The others are fairly even more different. I mean, if you look at the very simple designs at the top there, again, there's quite a lot of difference there because they're quite simple designs. That does make a difference, and this was brought out in fact in the Apple and Samsung case, which you may have followed a few years back, where Apple was suing Samsung for the iPhone design. Because the iPhone design was so simple, the changes, even though the changes were quite minor, they weren't. Those changes were not enough to be able to protect the design. Here's some more examples. I think these are probably more blatant. The one at the bottom, in fact, there's an additional issue there, and that would be copyright, because obviously there's a picture in that, and if you've got the copyright in that work, then you could probably succeed in preventing that one, as long as you own the copyright, of course. And then there's an example at the top there where somebody's using social media, so sort of touching on what Rosie said, into name and shame. So Zara copying or allegedly copying, I should say, allegedly copying some sort of motifs on some items there. And then the other one is, I think, Prada and ASOS. So a sort of variation on a sort of blouse. So maybe if you've all had a chance to look at the jackets, what does everybody think about the jackets? Do you think, first of all, have you identified any changes? And secondly, do you think those are substantial enough? And thirdly, do you think there would be a case to say that one jacket was the same as the other in terms of the design? Who thinks it would be an infringement? No? Nobody? No? Nobody thinks that? So, shall I just... So you've got the... So on this jacket here, you've got, especially when it's not zipped up, but when you've got a cuff here with a sort of protruding ribbed effect. You've got a collar which also has got a protruding ribbed effect. There are differences between the two. There's multiple zips on this one. So I don't know if you can see, there's actually 3, although it could look like there were 2. This one you've got the 2 zips. You've got the ribbed collar here, which protrudes, and you've also got that there. They've changed there's a few things that have been changed. The pockets are different on this one. You've got those pockets. And you haven't got any pockets here. You have there. But there's no zip on this pocket, whereas there's a zip on this pocket. There's a sort of bungee cord on this one, but not on this one. There's also branding on this one, obviously, which there isn't, so obviously on that one. And then you've got the seam at the back here and the seam across there. Although on this one you do have seams, they're not as pronounced on that as on that one. And then on the top, the collar, this collar as well has got the sort of some extra stitching, which isn't necessarily functional. But at the same time, I would say that this would be an infringement of this one, because it's the same overall impression. Now, I'd put this into context in that these are probably 2 or 3 years old, and on the market now there are actually quite a lot of jackets that look very similar to this. But at the time when this one came out, there were not very many jackets, or there weren't any jackets on the market that had this sort of ribbed effect collar, internal, together with multiple zips, and together with this sort of integrated ribbed cuff. And so the company had this.
Fabrics. I mean, the fabric, the weight of the garments are completely different. The functionality would be different. I mean, anybody would not buy the fire trap jacket. It's a much heavier jacket, and the super dry is a fashion item to boot as a rainproof. I mean, they're different garments.
That's the interesting thing about designs. It doesn't really take that into account.
It doesn't.
No.
Not the fabric.
Not the fabric. No. So you could have this in a yellow, or you could have it in a different type of fabric. You could have it in a sort of flannelette fabric. and it's about the shape. It's about the configuration.
Completely about the shape.
Yes, you can. I mean, you can protect colours as well, but certainly in terms of UK design, it doesn't matter. And in fact, that's why you can ignore the branding, which is on here. The fact that the branding here is irrelevant as regards designs.
When you say, like, I mean, as a designer, I would say those designs are so basic that they fall into a kind of non-design world, like in terms of their silhouette.
Well, obviously a jacket itself is basic, and a jacket is a jacket. But certainly when this jacket came out, who knows of any jackets that had three zips to close the jacket?
Ski jackets. All ski jackets have more than one zip usually.
But three?
Sometimes three, depends. I mean,
we didn't find any.
Ski jackets usually have 2 or 3 closures.
But some of those ski jackets they're not integrated jackets, they're separate. Those are jackets like, for example, the North Face does one where you have an internal jacket that's removable, and then you have an external jacket that you can have on top of that. And the point about this jacket is it has the effect of that, but isn't. It's a jacket that has, when you put it on, I'm not going to put it on yet today, but it looks like you've got at least 2 jackets on, because you've got the number of zips, and you've got this sort of layered effect of the collars and the cuffs. And that was what was unique about this jacket when it was designed, because there weren't any other jackets on the market.
High Trap is the original.
No, the Super Delights are the
something like that for about 10 years.
Yeah, exactly.
Seriously.
I don't know.
With that
saying
forest feature, with the cuff feature, with the twin zips, it's not wardrobe.
well, but this goes back beyond 10 years. This goes back to about 2006. So at the time it was first designed, it was novel.
So are you saying it is an infringement or not?
This, yes, of that. Yes.
This has a registration in it, the Fire Trap. It says that it's got a...
Oh no, that's just our internal labelling.
No, inside the jacket.
Yeah, that's to do with their trademark.
No, go where the contents are. They have registered it as a copyright. That if you go through, if you flip through, you'll see that they say it's registered as
Well,
a
that doesn't.
copyright.
No, copyright's different from designs. Copyright is something that attracts. That's to do with the words or the artistic copyright, whereas it's not registered as a design. Sorry.
Would Superdry have had to establish that that design in itself was an original and wasn't plagiarised from somebody else?
Yes, because if they want to say they've got rights in something, they've got to say it's novel, it hasn't been done before, and it's a similar test to the infringement test. You've got to say that what you designed is different when looked in the eyes of the informed user. So you've got to say that this is different from what has gone before. So
are there set parameters for that? A set number of elements within the garment that have to be truly original?
No, that's the point. You could change 30. You could change 30 things, but if those 30 things didn't make a difference on the overall impression, then that would mean you would still be
on the original design, the original Superdry design. In order to establish that as truly original, because as you quite rightly pointed out, it's just a jacket. How would they have established that was truly original? Are there certain criteria you have to meet?
Well, the designer would have to show through their own drawings that they've done, but they would have to show through their sketches.
Original drawings. Taken inspiration very directly from something else.
They could have done. And in this case, the inspiration was taken from luggage, where you have sometimes expandable luggage where you have more than one zip, and that's where the zips came from. But you can assert the design right. It's up to the person you're suing to say it's not original, and that's why it's important to keep records, because you should keep records of the design that you've created, plus dated records, because that not only shows that you created the design, but it also helps if you want to stop somebody from saying you copied theirs, because you can say you've come up with it independently yourself.
Did they win?
I can't say. It's confidential. So there's some practical tips which is in the handout, which sort of go to the what we've just been talking about really, and so if you want to have a look at those, we probably haven't got time to go through them at the moment. But so I'm going to hand you over to Steve. I'm obviously available afterwards if anybody's got any questions.
Thank you, Simon. So, what can we draw from this morning? We can draw from the fact that a jacket is a jacket. But there are various issues, and I think the questions have borne them out. There are urban myths around. It is important to know what you have, what you don't have, so far as your designs are concerned, to make sure where possible that you are protected, and to capitalise on that as and when you face infringers. Indeed, I think it's the case that the oldest footwear, and I draw on footwear because Simon threw up a slide showing various examples of footwear. The oldest footwear we've looked at is around about 450 years old. And if any of you are interested, I can show you the photos later. From Andrew, certainly Brexit means Brexit. So don't get me started. But Andrew has highlighted what businesses, what investors are prepared to pay for brands today, where they perceive growth. Undoubtedly, there is a wall of money out there that does, as Andrew quite rightly pointed out, need a home to go to. More imminently, and I can't emphasize this enough, there are just 6 months to go. 6 months to make sure that you are compliant with GDPR or risk the reputation that non-compliance can do to your brands. And then, as Rosie has quite rightly pointed out, the importance of social media, particularly in the world of digital, the online channel, that too cannot be underestimated. For more information, go to fashionlaw.co.uk. Please complete your forms. If you would like to attend any of our upcoming seminars for the remainder of 2017, please let us know. If you would like to join us for tea, coffee, soft drinks, no alcohol I'm aware of, but there are pieces to eat, and we'll happily discuss with you various issues that we've touched on this morning. Please do join us. But in the interim, please join me in thanking our speakers today, and a special thanks to Andrew as our guest speaker. Thank you.